All right, friends. So let's talk first about the features of, or the basic features of fundamental rights in India. So, what are the fundamental rights? Okay. So, anything which is fundamental. Okay. What does this mean? It means that it is basic. Okay. It is necessary. Okay. And it is foundational. मतलब जरूरत है इसकी. We need this. Okay. Without this, we will not survive. So, fundamental rights are the basic rights which are guaranteed by the Constitution of India to all individuals, citizens and non-citizens under Part 3 of the Indian Constitution. हमने बताया था, we had talked about that in the Constitution of India. It is divided into multiple parts, and Part 3, it contains the fundamental rights. Okay, so what happens here is that it is available to both citizens and non-citizens, but there are certain fundamental rights which are reserved for only citizens. Okay, all right. Non-citizens ko, yes, we had talked about, they are called aliens, but aliens are also two types. There is a friendly alien and then there is an enemy alien. Okay, so enemy alien have more restricted rights compared to the friendly alien. Okay, so ये जो fundamental rights हैं, they ensure justice, equality, liberty and dignity of individuals, and they act as a check on the state's power. So what they do, fundamental rights, they check the state's power. Okay. Now let us talk about the features of fundamental rights. So first of all, the fundamental rights are claims against the state. So this is a previous year question, by the way. Okay. So these are claims and against the state. So why they are claims against the state? Why? Because the fundamental rights are there to place a limit on the state's power. So this is a negative connotation. मतलब इसका एक नेगेटिव काम है. What is it doing? Is it enabling? Is it enabling something? No, it is not enabling. Okay, it is restricting. It enables in certain areas. Okay, it enables in certain areas. जैसे कि आर्टिकल 21A में हम कह सकते हैं that it asks the government to do something, but in general, the fundamental rights are negative in nature. They place a limitation, whereas DPSP, they are positive in nature. Why they are positive? Because they are basically asking the state to do something. Okay, they are basically enabling the state to do something. Okay, whereas in fundamental rights, they are placing a limitation, asking them to not do something. And they prevent the government from acting arbitrarily and ensure that citizens can exercise their freedom. Okay. Example, so Article 19, it guarantees freedom of speech, meaning the state cannot impose unreasonable restriction on speech. Okay. So यहाँ पर जो है unreasonable power wielding. Unreasonable is the word that you are looking for. Unreasonable power wielding shall not happen. Okay. Let us talk about a case. So we have the Menka Gandhi case, and the Supreme Court ruled that no law can arbitrarily restrict fundamental rights. So what had happened here was Menka Gandhi, she was married to Sanjay Gandhi. Sanjay Gandhi, he unfortunately passed away in a plane crash, and Menka Gandhi's passport was seized under a 1967 order by the Ministry of External Affairs. So this order, she went to court, and Menka Gandhi case was a watershed moment in Indian judicial history. And ये जो order था, इसको इन्होंने बोला कि this is unconstitutional. You cannot curtail Article 21 of a citizen, that is right to freedom and liberty. Okay, so this was very, very important. Fundamental rights. Now let us talk about one thing. Fundamental rights are not absolute, but they are qualified. Okay. So fundamental rights are subject to reasonable restrictions. You cannot do as you please. You have to do as you please within the boundaries of the law. Okay. So the state, it can impose restrictions for reasons such as national security, public order, morality, and the sovereignty of India. What is an example? Freedom of speech under Article 19, Clause 1, Clause A can be restricted under Article 19(2) for reasons like incitement to violence or defamation. So suppose I am saying that इस XYZ religion के लोगों को मार दो और ABC religion वाले लोगों को मार दो. Okay, so I'll say that okay, this is my freedom of speech. But what I'm doing, I am inciting people. Okay, I am inciting people, or I am doing something which is against the public order. So my freedom of speech is not absolute. It is qualified, means I have to qualify certain criterias that I am not pandering to violent people. I am not inciting violence. I am not defaming anybody. Yes, defamation also. Defamation में क्या होता है? I'm saying, like, let us say I'm saying Wazik is a bad boy. Okay, Wazik is not a good person. Okay, so what I'm doing, I am defaming Wazik. Okay, so I will say that I have a freedom of speech and expression, but what I am doing, I am also tarnishing your Article 21. That is, Article 21 में right to reputation भी आता है. So my Article 19 should not be used in such a manner that it will tarnish your fundamental rights. Okay. Kedarnath Singh versus State of Bihar में it upheld restrictions on freedom of speech to prevent sedition. मतलब मैं ये कहूंगा, जैसे एक होता है ना, भारत तेरे टुकड़े होंगे, जो JNU में they had started. So the JNU chaps, they can argue that it is my freedom of speech, but what they are doing, they are inciting violence, they are against public order. Okay, after they are against the country, they are doing sedition, treason. All right, so it is not absolute. It is what? It is qualified. Please do remember, it is not absolute, it is qualified. Okay. So why are some fundamental rights available only to citizens? Okay. So what are the fundamental rights available only to citizens? So right to equality, Article 15 and 16. It is available only to citizens. It is not available to foreigners. Right to freedom, जो 6 rights हैं, उसमें जो है आपका citizens को available है, whereas foreigners को नहीं है. तो एक और चीज आपको समझनी होगी, that there was a case where a German national, he had come to India and he had participated in the Shaheen Bagh protest. So the Indian government had cancelled his visa and deported him back to Germany and blocked his entry back into India. Whereas it did not do anything to other girls and other boys who were protesting there with him. But they targeted the German person. Why? Because for the girls and boys of India, Article 19, that is, right to protest, it was present. Whereas for the foreigner, it was not. Right against discrimination, this is available to the citizens, but it is not available to the foreigners. Why? Because what happens here is that there is a place of birth discrimination for certain exams, for certain benefits which are being disbursed by this republic. Place of birth can be a criteria, like place of birth in India. Place of birth is in India, so the government might ask you that, okay, I'll give you subsidy, but you have to be an Indian citizen to get that subsidy. Okay, so the foreigners can be discriminated against. But within India, a person born in Delhi or person born in Haryana or person born in Tamil Nadu, they will not be discriminated. Okay. Then right to constitutional remedies. Okay. Right to constitutional remedies जो है ये आपको present है, और ये जो है right to life and personal liberty, it is present to both citizens and foreigners. Okay. सिटीजन्स और फॉरेनर्स को अवेलेबल है आपका आर्टिकल 21। कंफ्यूज मत होइएगा, यहां पर भी मैं टिक करूं या यहां पर टिक करूं, बात बराबर है। आर्टिकल 21 यहां पर भी फॉरेनर्स को अवेलेबल है। ओके। Citizenship based rights ensure that foreigners do not interfere in the political and economic affairs of India. So only Indian citizens can apply for government jobs under Article 16. So if you would have seen in the UPSC notification, they had asked you that, okay, you have to be an Indian citizen to apply for these particular jobs. And if you're not an Indian citizen, you will not be able to apply for these jobs. Fundamental rights are justiciable. Now, what is justiciability of a fundamental right? It means that it is enforceable by courts. And if the government or any authority violates fundamental rights, the courts can intervene. That is what it is meant, okay, by justiciability. So case क्या है? केशव नंदा भारती versus State of Kerala. So Supreme Court ruled that fundamental rights form part of the basic structure of the Constitution and it cannot be taken away. So ये जो fundamental rights है उसको basic structure के अंदर रखना, it reinforced the justiciability of the fundamental rights. Okay, justiciable. What are DPSP and fundamental duties? Are they justiciable? What about DPSP and fundamental duties? They are not justiciable. They are non-justiciable. You cannot go. See, the DPSPs, they are made non-justiciable. Why? Because it is according to the capacity of the state. Okay, the state will act upon its capacity when it comes to the DPSP, whereas in fundamental rights, you need immediate remedy. ऐसा तो नहीं हो सकता है ना, there are certain people, a group of people are there who are bonded labor, and the state will say कि I do not have the necessary resources to rescue them, so I will take my own sweet time. No, if your rights are being abrogated, every moment is precious there. Each minute your rights are being abrogated is precious. Okay. So fundamental rights are available against state action only or against private action as well. Let us see this. So it is mostly against state action, but some rights are enforceable against private individuals as well. So इसमें क्या है? Against state action हम देखते हैं तो right to equality, right to freedom आ जाता है. But there is also against private individuals certain sanctions like abolition of untouchability. देखिए untouchability जो है, the state should not practice it, as well as the fellow citizen should also not practice it. Then only it will be a successful article, because untouchability, it can be practiced by both the state and fellow individual. So both of them, they are not allowed. Then abolition of forced labor. Forced labor the state can also do, as well as the fellow citizen can also force you into doing forced labor. All right. So that is why private individuals के case में certain cases are there where it is the fundamental rights are actions against private individual, but in majority of the cases they are action against state action. Okay. So in the Vishakha versus State of Rajasthan, जहां से विशाखा guidelines आप पढ़ते हैं, Supreme Court ruled that private companies and employers must ensure protection against sexual harassment at workplace under Article 21. So who is doing sexual harassment? A fellow citizen is doing it. And it is sanctioning the action of the fellow citizen by telling that person that, okay, you will not be doing this because you are abrogating or you are violating the fundamental rights of your fellow citizen. Okay. Now, are fundamental rights sacrosanct or permanent? So please remember, they are not absolute. हमने अभी just बोला था, they are not absolute but qualified. They can be amended or suspended and during an emergency. So Article 368, it allows the Parliament to amend fundamental rights but they cannot be destroyed. Please remember why they cannot be destroyed. Can you tell me why they cannot be destroyed? Why? Because in the Kesav Nanda Bharti case, they have been declared as part of the basic structure. ये जो है बेसिक स्ट्रक्चर का पार्ट है, तो इनको जो है आप अमेंड कर सकते हो, सस्पेंड कर सकते हो, चेंज कर सकते हो, लेकिन जो कंसेप्ट है पार्ट 3 का, फंडामेंटल राइट्स का, उसको यू कैन नॉट टेक अवे. ऑलराइट. सो ये जो दे आर नॉट सैक्रोसॉन्ट एंड परमानेंट, they can be taken away in certain cases, they can be suspended, they can be amended, they can be changed, but they cannot be destroyed. The concept of part 3 has to remain there. Now, who defends and guarantees the fundamental rights? It is the Supreme Court under Article 32 and High Courts under Article 226. ये याद रखिएगा. Article 32 and Article 226. इन दोनों को यूज करके सुप्रीम कोर्ट और हाई कोर्ट जो है, दे कैन प्रोटेक्ट द फंडामेंटल राइट्स, दे कैन पास एक्शन against the fundamental rights, they can give judgments against the abrogation of fundamental rights, and the president and governor take an oath to uphold the constitution, which includes the fundamental rights as well. So which is broader? Article 226 is more broader, or Article 32 is more broader when it comes to power? किसके पास ज्यादा पावर है इसमें? Article 226. Why? The high courts have more power, okay, compared to the Supreme Court, because high courts, they can issue writs both for fundamental rights violation and normal, जो आपके नॉर्मल आपके राइट्स हैं उनके लिए भी ये इशू कर सकता है, लीगल राइट्स के लिए भी इशू कर सकता है. वेयर एज Article 32 is only for part 3 rights. Okay, whereas Article 226 it includes part 3 plus your legal rights. तो होता क्या है इसमें? बेसिकली द हाई कोर्ट जो है उसके पास ज्यादा पावर है. ओके, हाई कोर्ट के पास ज्यादा पावर है, ब्रॉडर पावर है when it comes to upholding the rights of an individual. That is why the Supreme Court advises, okay, the Supreme Court advises the complainant or the petitioner to first go to the High Court to seek remedy before coming to the Supreme Court. Okay. And Dr. B.R. Ambedkar called the Article 32 as the heart and soul of the Constitution. So now let us see, can fundamental rights be suspended? क्या फंडामेंटल राइट सस्पेंड हो सकते हैं? Yes, but only during national emergency under Article 359, and Article 20 and 21 cannot be suspended even during an emergency. आपका जो राइट टू लाइफ एंड लिबर्टी है और जो आपके प्रोटेक्शन है अगेंस्ट अरेस्ट एंड डिटेंशंस, उसमें जो है उसको आप ड्यूरिंग इमरजेंसी भी नहीं हटा सकते. बाकी के जो है राइट्स वो सस्पेंड हो सकते हैं. So during an emergency, citizens cannot move courts to enforce fundamental rights, okay, except Article 20 and 21. Okay. So during the emergency of 1975, the right to freedom of speech was suspended. So Article 19 is the softest target when it comes to suspension of fundamental rights. जब भी war होता है या कुछ ऐसा situation बनता है, so the people, they do not wish, the government rather, they do not wish that there is freedom of speech. Why? Because the newspapers, they might be publishing sensitive data. जैसे पाकिस्तान के इंडियन टैंक्स किधर हैं, ओके, इंडियन आर्टिलरी किधर है, समथिंग लाइक दिस. इफ दे विल पब्लिश, देन इट विल बी प्रॉब्लमैटिक फॉर द इंडियन डिफेंस फोर्सेस. सो इसीलिए जो है सिटीजन्स के, मीडिया हाउसेस के जो आर्टिकल 19 है, राइट टू फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, उनको कर्ब कर दिया जाता है. ओके. Then scope of fundamental rights, so they extend across India and apply to all levels of government, union, state, and local. And foreigners enjoy limited fundamental rights such as Article 21, the right to life. And our fundamental rights self-executory, मतलब खुद से ही execute हो जाएंगे just by the virtue of existing, or do they need legislative action? जैसे अगर fundamental rights है, तो क्या उसमें अगर हम देखें So do they need legislation of parliament to, realize their full potential or realize their potential, or just by the virtue of existing, they can be executed? तो यहाँ पर right to equality, they are self-executory. You don't require a parliamentary law. Same goes for right to freedom. Okay, then right against exploitation also, you don't require, they are self-executory. But what happens is that if the parliament wants, they can come up with legislation to define these things better, but they are self-executory. But let us say article 17, okay, जिसमें अनटचेबिलिटी को अबॉलिश किया गया है, सो सम काइंड ऑफ prohibition needs to be there. The Civil Rights Act, it had to be there so that there is punishment for that untouchability. Okay, because if you are doing indulging in untouchability, there has to be certain punishment so that Article 17 can be effective. Otherwise, it will only be in the constitution and nothing will happen on the ground. Okay. Right to constitutional remedies, they are self-executory. Right to education, it requires the Right to Education Act. Otherwise, what happens? There is that right to free and compulsory education. You just say that, okay, there is right to education, but you need something na, to execute it. Otherwise it is, there needs to be allocation of resources, there needs to be allocation of teachers, there needs to be allocation of seats in private schools. So that is via, that cannot happen via the constitution, that is happening via a separate legislation. So right to education, merely writing right to education will not ensure right to education. You needed a Right to Education Act which detailed the provisions which made it possible for an individual to have a right to education. Okay. So self-executory rights, rights which can be directly enforced without requiring any supporting law, they are called as self-executory rights. And rights that need legislative action, so some kind of parliamentary law are needed to be passed to implement them. Okay, so these are the features of fundamental rights. Any doubts that you guys have till here? किसी भी तरीके का डाउट है आप लोगों को, अभी बता दीजिए, because this is over. क्लियर मैं मानू? शुड आई say that everything is clear, no doubt? Anyone? No? पक्का? ठीक है.